West, Duke Sims, the Don. Oh, shit.
And they got the Kiwe pop star. I'm on time. What's the real? What's the deal?
Oh, man, we got the content.
Oh, shit.
Well, you know, when people pull up, they know we going to put our credibility on the line. We're going to do a lot of checking and reading so that you could be on par with how we come to the conclusions we come to. You know what I'm saying? Today, we got the boy Damu Kiwe Converstaions reacts to Bmf Bleu Divinci admission of a proffer agreement.
Whoa, wait. Hold on. Is this newfound information? That's
newfound information.
Oh,
Shout
wow.
out to the boy Smokey. You know what I'm saying? New member of the ETE Damu Kiwe family. You know what I'm saying?
Damn, dudes.
Hey, bro, I'm just saying he admits that he signed a proffer.
Okay.
He also admits that he went and sat down with them people, right?
So basically, that's not the argument because we know he did that. We just curious on what the fuck you told them people and how the fuck you get a queen of the day.
Well,
pass,
first and foremost, you ain't supposed to sit down with them people in the first place, right?
Correct.
When we talk about sitting down with them people, I'm talking about you're in jail and your lawyer, the United States assistant United States attorney, and then you got the federal agency questioning. You're not walking in with the questions that you willing to answer. You're going to cooperate or the deal's off the line. In this case, Blue deal was for a safety valve. Safety valve, when we get into the work, I'll be breaking it down when you see his maximum exposure, the meaning how much time he could be facing, right? Mandatory minimum, right? And the only way to come up under a mandatory minimum of the old law, obviously laws change and judges got a little bit more discretion after Blakely versus Washington, the Booker case, the Emmeline Fam case, and these historic legislative precedents, right? So a little things changed, but at this time that he caught this case, we wasn't dealing with that. You still had mandatory minimums, and it kind of binded the judge's hands on what he could do, even if he wanted to go down, unless you cooperate, right? You could cooperate and get a safety valve. You could cooperate and get a 5K1. You could cooperate and get a Rule 35. B. You know what I'm saying? So you got options. You know what I'm saying? You got
like a quarterback.
And so the fact that he signed an agreement, majority of the people in the feds, because of their history of like a 98% trial conviction rate, when the feds come raid you, they already got their snitches. They already got wiretaps. Mike got you on camera doing a controlled buy. You know what I'm saying? So, and they're going to come to you and tell you, hey, look, you got this. That's a mandatory minimum of 10 years. You got a prior. So double that up. That's 20 years mandatory you finna do. And if you go to trial, you're going to get more than that, right? Damn. So this is what we got. So unless you want to be the tough guy and do this 20, 30 years, you're going to work with us. You're gonna compromise everything you said you stood for. You know what I'm saying? And be a house nigga, and you finna give us some information.
I know some master. I'm not doing that. I told you.
No, Blue didn't say that, my nigga. Blue went and met with him. He admitted he went and met with him, my nigga. You know what I'm saying? It was I guess they had a lot of leverage, you know. Nigga, he got that mandatory minimum, but hit that like button when you come in. Let's get in the chat real quick. Mike P, salute. Hashtag ETE, ETD. Chuck, stay active in your Chucks. Damu Kiwe Conversations. That's a fact.
Salute.
We active in our Chucks over here. Evelyn Holly, salute. I see you with the Henny glass and the Chuck Taylors. That's how we do it over here, man. You know what I'm saying? Oh, yeah, man. Salute. Amazing Glar, Sis Bros. Salute. Salute to you too, man.
Very
Heidi
unique name.
There go Heidi B, looking gorgeous as ever. I'ma call y'all back.
What up?
Always positive. Yeah, what's up, bros?
What's up? What's up?
Hey, yeah, they know what's up. Hashtag ETE, man. Expose the exposers. I don't think that anybody should take lightly those within our community that sell our people out. And if ever there was selling your people out, it was turning them into the slave master. Cooperating and working with them to get those who had enough courage to say, fuck the law, and I'm breaking away from the plantation, or I'm doing whatever I'm doing, and they're doing it with you. Or you got wind that they were doing it. Ain't nothing wrong with taking a plea agreement, but you don't meet up with the FBI to make your plea agreement. Your lawyer goes and negotiates with the U.S. attorney. This is in the feds. With the U.S. attorney, see what the best offer is. You're going to take it or not, or go to trial, and more than likely get convicted if the feds got you. You know what I'm saying? Like a 90-some% conviction rate. But let's get into this first, what you call it, man. We're going to get into this first video real quick, man. Make sure that y'all know what's going on. Shout out to Street TV. Does a safety valve mean you cooperated with the government? And then in parentheses is Bleu DaVinci. So you got FG. Shout out FG, real stand-up brother. I was in MDCLA with him. He was on 5 South with my crime E, Nino Brim. Y'all might know him from Hit Your Bremen with me. We was on I was on 7 South and 6 South, and then 6 North and the whole after the chicken riot. But let's get into this content, man. I ain't gonna hold y'all up.
I wanted to address a question that was sent into us on, I believe the question was sent into us on Instagram. And yeah, go tap in with our Instagram page. It's Street and Scholars, street.and.scholars. And there was a really interesting question that came in. And I wanted to shout out the person that sent it. I'm gonna have to find that in a moment. But the question was, and it was mostly to you, FG, because of your knowledge and experience of the federal system. But the question was, can you talk about Bleu DaVinci, aka Barima McKnight? Because JDiggs was mentioned something that he was involved in a safety valve. What does safety valve mean in the federal system? And if you guys are familiar with JDiggs, he just did a diss song against Whack 100, and he had a bar in there saying something about Bleu DaVinci told. And I guess JDiggs is referring to something that's called a safety valve. I've never heard of a safety valve, but what does that mean in the federal sentencing guidelines?
I've heard of safety valve, and I think everybody in the feds heard of a safety valve. And the reason we heard of it because we never knew nobody who actually had one, you know. So back then in the federal system, we was trying to do all our due diligence on all the federal laws and statutes just based on any time somebody come through with something. We wanted to make sure that, you know, we knew what the rule was or the law was pertaining to it, you know what I mean? So we know how to handle business or not, you know. But I never knew nobody that was eligible for a safety valve, Alex, but what it was, if you had minimal, and I mean very, very minimal criminal history, like you could only have either less than 3 or 4 criminal history points in order to be eligible. That's for one. So you had to have damn near no criminal history because a lot of people don't understand.
So that's one of the prerequisites. You got to have 3 or 4 or less points on your criminal history category on the United States sentencing guideline. I don't know if Blue did or not, but that's just something that's part of the prerequisites to qualify for a safety valve.
In the federal federal guidelines, when they get to talking about criminal history points, you could have a ticket and it can be considered as one criminal history point, you know. So you know, you damn near had to have a squeaky clean record in order to get one. What they try to say that the safety valve is you do have to basically make a statement on what happened in that case. In one way, they're gonna say it's not snitching and it's not telling and it's not informing. But if you read the structure of it, you do have to basically debrief on exactly what happened in the situation you was in. Now, if you got a co-defendant and you try to get a safety valve, you have to tell exactly what you and your co-defendant did. Now, if you got a fraud case and you trying to get a safety valve, which, let me be clear, safety valves you can only get a safety valve for certain cases anyway. So say if your case only carried 2 or 3 years, you're not eligible anyway. It have to be a substantial amount of time that you're facing. So if you get a safety valve and you basically tell on what you did as far as the situation, you debrief on everything you did. You know, most of the time
Rule number 3, you can't get rich slow. When I owned 100 houses,
commit a crime, it's either with somebody or against somebody. So you have to tell all this what happened. The homies do believe that a safety valve, you debriefed, you gave up a certain amount of information, because the information that you've given up needs to be useful to the government. Whether they use it or not, it needs to be useful and substantial to them.
Whether they use it or not, and the homies in the federal system who been going through it, not niggas from the state prison system, not niggas from the juvenile justice system, from the federal prison system. When you hit that yard, if you got a safety valve on your sentencing, that's snitching.
In order for them to grant you that safety valve. So at the end of the day, we did always call it telling. I don't know Bleu DaVinci situation. I don't know if he had co-defendants. I don't know. The only way I could see a safety valve working is if you commit a crime by yourself, you're the only one on the case, and you basically debrief and tell exactly what you did and who else was involved. And only people other can have been involved that was acceptable to me is the victims. So if you were able to do that, then maybe the safety valve worked out. But at the same time, I did know Bleu DaVinci. Bleu DaVinci did a Proffer statement as well, if I ain't mistaken. Yes, you know what I mean? You know, so when you do that a Proffer statement, Alex, you know, speaking specifically of Bleu DaVinci, you know, you debriefing anyway and giving up a whole lot.
So you did a Proffer. You had signed a Proffer agreement, debrief, which in state prison, if a person debriefs, they're no good. For somebody to go protective custody, they don't know if they really going over there to hit somebody on that side, on the PC side, or if they serious, they force them to debrief. And that's why they're considered bad, being on the S&Y yard.
Making statements, you know what I mean? So Bleu DaVinci's situation is different. So did Bleu DaVinci get a safety valve? Is that what JDiggs saying?
Yeah, that's what JDiggs is saying, and also a few other people. There's even an author named Mara Shalhoub who wrote a book about BMF, and she talked about the cooperation of Bleu DaVinci. But I want to read with this paragraph from this lawyer's website called lawbayback.com. He has this whole entry on what exactly a safety valve is, and in this paragraph here, he says, it is generally safe to engage in a safety valve debrief. Many inmates mistakenly believe that the safety valve debriefing is snitching or informing. Debriefing rarely results in any new arrest, but only serves to inform the government of what really occurred in the offense, and also serves as a kind of penance for an individual charged with a drug crime being completely honest with the prosecutor about what really occurred. And that part right there is kind of it seems like this paragraph is a little bit contradictory, because the attorney in here is saying that it's not necessarily snitching or informing, but you have to tell the government everything that happened. So how is it not snitching or informing if you have to tell the government everything that happened? And if you have co-defendants, you got to tell everything that you know of the co-defendants. So I think this attorney is trying to have it both ways in the way he wrote this here in this paragraph, FG.
No doubt, but at the same.
So You have a lawyer trying to say and define what snitching is to us by what they do with the courts, right? Saying it is generally safe to engage in safety valve debriefing. Many inmates mistakenly believe that safety valve debriefing is snitching or informant. If many inmates is saying that debriefing is snitching or informant, and you got Bleu DaVinci admitting that he debriefed, admitting he signed a proffer agreement, that he sat down with them people, a federal agency, his lawyer, and an assistant U.S. attorney. Nasty work, bro. Let's go.
Time, like I said, it seemed like the only way it could be acceptable if you was just pulled over with some drugs and you were caught, you were arrested, you know, and you went to, you know, file for a safety valve. You didn't have no criminal history, you know, or very minimal, and you went and told them everything you did, you know, and I don't see them granting it that way, because I'm almost thinking that in order to have a safety valve, bro, you got to give them something. You know, most of the time it's not nothing about you, because they already know what they know about you. They know they got you with the drugs. They know they wants to know where you got them from, who helped you get them, who helped you acquire them, who were you going to sell them to. See, they not telling you all this part. You know what I mean? So me personally, I believe the safety valve, man, is a setup, you know, for you to make statements, or, you know,
Do you know the U.S. solar company's nasty little secret? It turns out that if you live in Wisconsin, they have to give you.
And once you start making statements, that's when the telling and the snitching come in.
Yeah, there's this author I mentioned named Mara Shalhoub. She wrote a book about this, and I want to read a part of something that she wrote regarding what Bleu DaVinci did. She says here, and she says here, and this is from her website. Her website is called creativeloafing.com. She says here that Bleu DaVinci received a 5-year, 4-month sentence, less than the government's recommendation, due in part to the fact that he agreed to share information with authorities. But that information turned out to not be useful, however, because the government had already built most of its case against BMF. Bleu DaVinci also.
So he received less than what the prosecutors recommended, because he agreed to give information to the prosecutors and the federal authorities. I mean, how much more does it take? I'm just saying, AIL. I guess if you provide information about others, you can tell them about yourself whatever you want to. That's a separate responsibility for your actions. But once you start telling them about everything with the case, and that's what they're going to ask about.
So let me ask you this. Well, go ahead. Yeah. How was you done? Go ahead.
Who was the killer? Who was the supplier? Who was the hustlers? All of these different things is going to be required for you to tell. So you're giving information, criminal information about people you know, to the federal authorities and the government. That's what you have to do to get a safety valve.
I got a question. So I've heard him say stuff like this. I didn't snitch. I just told them what they already know. Hold on. Listen to what I'm listen. This is for education purposes, everybody. Listen very slowly and clearly. I did not snitch. I just told them what they already know. Basically confirming that what they're asking me, yes, that's what it is. So I've heard people say that, Deuce, and the question is this. If I told the feds, the DEA, the police, the detective, what they already know, is that snitching with confirmation?
That's exactly what it's doing, is confirming what they already know. But the crazy thing is, how do you know how much the police already know?
That part. Well, we know they hit you with this one, Deuce. Well, we know Lamonte Sims. We know that he's one of the guys. We know that Yael, the Kiwe pop star, Larry Grant. We know he's one of the guys. We know that they're co-hosts. They're from Damu Kiwe Conversations. They seen the guy. They beat him up. We know that. So just tell us that you seen him beat him up, and you just know that. Basically, we know that they beat him up, and dude be like, well, I mean, shit. If y'all know he beat him up, why you need me to say something? Is that snitching?
Hold on. We got Diamond said Blue did not have to sign a proffer. He took the safety vow and agreed with the information the snitches already told him. Well, does that make him any different from the snitches? I mean, if you confirming what the snitches said and they snitching, doesn't that make you a snitch? Let me see.
So, dudes, can I'm gonna read Circle Media real quick. 400 Circle Media, $2 super chat, 100. Salute. Blue just a rat. Salute to you, 400 Circle Media, for the $2 chat. Any and everything that's given to the Damu Kiwe conversation, we highly appreciate it. Bless you, your tribe, and your family. So, Deuce, if somebody said exactly what I just said right now, we know that this is Deuce and Yael in the video. We know they just beat this dude up. We know that they stumped him out. We just need you to confirm that. And the dude replies and say, well, if you know this, why do you need me to act? Why do you need me to do it? If you know this, what you need me to do it for?
Right. Well, because you need confirmation.
No, is that snitching?
What part? Just you asking that one question?
Yeah.
Well, first, you wasn't even supposed to be sitting down, my nigga. You on a hot seat now.
You know? No, I'm saying if they get him and he say, what you need, if you know that's him, what you asking me for? What you need me to confirm it for?
Right. Well, common sense, they don't need confirmation. Once they got two confirmations on a conspiracy, all it takes is two people to confirm one fact, and the juror of their peers can find, and it'll be held on appeal. But he said, break. Oh man, we ain't talking about no break. Okay, let me play devil advocate. Can we put some DaVinci said to somebody going to? I know Big Me said he told on the limousine. Yeah, we're not talking about the limousine. That's in the paperwork. There's nothing in the paperwork of the case that says he told on nobody. And that, as I heard, I didn't double check on that fact. As I heard, that they come to find out that wasn't even him who's supposed to told on the limousine. I can't confirm or deny that, but I did hear that a lot. But when you say that you're going to go debrief, bro. If my co-defendants told me they went to debrief, you have to sign a proffer agreement to debrief. The safety valve is the reward for the debriefing, and it's still discretionary at that, because there's other criteria, and a judge still at sentencing has to award you that. So to get the safety valve, to qualify for the safety valve at sentencing, you have to sign a proffer agreement. You have to sit down with those people. You have to debrief. Let's get back into this, because we got some paperwork, and it's a lot, man. But we ain't gonna be.
Was not willing to testify against other defendants.
This shit.
And this is a quote from his attorney, according to Mara Shalhoub. His attorney says he would have liked to have cooperated if he could have. David McCusick says, but he didn't have any useful information. So that comes directly from Mara Shalhoub, who wrote the book on the BMF and who covered this case. It sounds like borderline snitching to me. What do you say?
I mean, it ain't borderline. You know what I mean? If he gave up any information pertaining to the gang outside of just pleading to his plea agreement, you know, now let me be clear. When you take a plea agreement, you know, the plea agreement in it is going to say, do you admit to these charges? charges gonna be, did you willfully sell cocaine to whoever you sold it to, whether it's an agent or whatever? Did you sell cocaine to? Did you commit the crime? Basically, that's what it's saying. Now, if you have a co-defendant, you know what I mean? You have to go to your co-defendant and say, bro, listen, they got a deal on the table. We both, in order to take the plea agreement, they're gonna sit up there and say, we willfully sold some cocaine to an agent. You know what I mean? And hey, homie, are we gonna take this deal? If my co-defendant say, no, I ain't going to take the deal, then I can't take the deal because I'm not going meant to sell into an agent based on because my co-defendant want to fight his case however you want to fight it. You know, even if it's in my best interest to take.
So even if it's in my best interest, I get lesser time to admit that I did this with this, what you call it. I'm not going to take the deal before I confer with my co-defendants and make sure that I'm not hindering or saying anything that implicates them or confirm any acts of or crime. That's the standard, right? What's the name just said, yep, if they already know, then be quiet and lawyer up. I thought that's how we was laced. You know what I'm saying? That's how I was taught. But let's go.
The plea, you know. So now, with that being said, that happens all the time when people take a plea agreement. Now, when you get to talk about proffer statements and safety valves, information need to be given outside of the information pertaining to what's going on with your case. That's the part that they not telling you. You know what I mean? That's the part that they not putting out there. You know, they know exactly what you did. They don't want to know exactly what you did. They want to know the extra stuff.
They don't want to know what they already know. They want to know the extra stuff. Right.
So can I ask you this? Because right there, they don't want to know what they already know. They want to know the things that they don't know, which is the extras, correct? Mm-hmm. So I'm gonna revisit the comment Diamond just said, right? So he said Bleu did not have to sign a proffer. He took the safety valve and agreed with the information the snitches already told on him. So if he agreed with the information that the snitches told on him, right, and the safety valve is for him to get what, lesser time, correct?
Yeah.
Okay, so the snitches told on him. What did he say to get? Because he went back to the people and sat down with them. He didn't just. It wasn't just one.
No, he's in jail already, serving time, and said, "Okay, I'm gonna go talk to the feds. I'm gonna go talk to the assistant U.S. attorney, and I'm gonna have my lawyer with me." So yeah, that was like not a court date. You know, you ever heard niggas going to court without court dates?
Yeah, that's that. I got something to tell you.
Weird, nigga.
Right. That's that. I got. Hey, warden. Hey, guard. I got something to tell you.
Right. But Diamond said the driver Ralphie is the one that told on the limo. You know what I'm saying? Hit that like button on y'all way in. But bro, FG, he really on this G shit right here when
you know what I mean? And those questions are coming. You know, in that part where it keeps saying, you know, you have to be willingly and truthfully about everything, and they asking you all kind of stuff. And that's what people that's taking these these safety valves and making these proffer statements not understanding, bro. You making a statement, you know what I mean, about the crime, you know, when you either just take your deal and plead guilty and leave it at that. They know what you did already. So to me, I don't believe in the safety valve, you know, especially when these dudes are going to jail with more cocaine than a.
So how much did it cost to fill your tank? $100. How much is the car payment? $140.
We got
a little bit, you know what I mean? You know, I don't understand it, you know, but I can't honestly say that I don't know nobody personally who've ever had a safety valve for me to personally just ask them to break it down. But from what I done read about it, and I done read many reviews on it, you know what I mean, that safety valve is basically providing information for a lower sentence.
But it's according to all accounts of whatever he provided to the government, it was not useful. And it was information that they already had. What if, let me just play the other side. What if the Bleu DaVinci says, okay, I'll cooperate with you guys and do the safety valve debrief, but he already knows everything they know, and he already knows what he's going to say, and he's not going to add anything to what the government already knows. And then at the end of the day, it turns out his debrief did not lead to any new arrest, to any new information. If that is the case, do you still put him in that same category?
I mean, you don't make statements, Alex. You know what I mean? You don't tell them nothing. You know what I mean? When it's time to take a 10, 20-year deal, you're going to plead guilty to what they say you did. You know what I mean? You're not going to add no statements to it. You know what I mean? You're not going to give them no information at all. You know what I mean? That's just the real, man. I ain't no thin line between motherfuckers. Now, like I said, I don't know Bleu DaVinci or his situation. You know, I'm going by what you telling me at this moment. But at the same time, man, I don't give a fuck who you is. You don't go in there and make no statements about nothing. You know what I mean? You go in there telling people your name and you know your address if need be. You know your baby mama number so somebody can call and that little stuff like that. But at the same time, man, you don't go in there and you don't talk on nothing about the crime itself. You know what I mean?
The essence of the principles and the code within our community, right? You don't go in there first. You don't damn 400 circle. Go ahead, Yayo. Let's get that out before I elaborate on that.
Man, we got 400 circle media with the $2 super chat. Blue can't rap, but he can snitch. But 400 media circle, man, we appreciate any and everything that is donated and given to the Damu Kiwe conversation team. Bless you, salute you, man, and to you, your family, and your tribe, man, from Damu Kiwe conversations.
If the code is you don't go in there and tell them people nothing, I do not waive my Miranda rights. You have a right to be quiet, right? You don't never got to worry about being suspected of being a rat. Somebody got a hot mic, bro.
Mute up.
You don't never have to be suspected of being a rat when you keep your mouth closed. The moment you start providing statements about a crime, your crime, or any crime, you're snitching, right? You can talk about your crime, everything you did. I can't hold that against you. You know what I'm saying? Just like my co-defendants went into court. We went to trial, but my my other co-defendants went in, didn't sign the deal, kind of what Thug just did. Didn't sign the deal because they was talking bullshit and all the conspiracies to these other bank robberies. So they did an open plea and they told them what they did. Well, who had the gun? I had the gun. And what you do? I robbed the bank. Did you get the money or did your co-conspirators get the money? I don't have no co-conspirators. This is what I did. And what are you saying you did? I did this, I did that. Did your co-conspirators? I don't have no co-conspirators. Just like that, bro. So the minute that you go sit down with them, out of your way, remember, this ain't a court date. Nigga, this is a special meeting while you're incarcerated with the federal government, nigga. A federal agency, DEA, ATF, FBI, nigga. Nigga, you're going to go meet with them, the U.S. attorney and your lawyer, to talk about, answer all questions truthfully about the crime. And if they find out that you're lying, then you won't be qualified for the safety valve. We almost finished with this video, and then we're going to get into this work. Exclusive work. Nobody got into it yet. We going to get into it. Nasty work.
Damu Kiwe.
Especially when you're working with the feds. You ain't going in there to fight them. You going in there to see what the best deal you can get. Ain't no fighting them. They done already got you. They got their case sold up. You know, it is a few people that have beat the feds. It's rare. You know what I mean? But for the most part, in a lot of these drug investigations, bro, they got so much on you. I mean, what is there to fight? So in order for you to, the amount of drugs that these dudes had in their case, man, most of them cases, them 841s, US 21 USC 841 drug cases, they had a 10-year to life. You know what I mean? All of them. They had a 10-year to life, bro. You know what I mean? I don't care. My first drug case ever. I only had one in my life. It was a 10 to life. You know what I mean? And I got convicted on 98.8 grams. You know what I mean? These people wasn't playing, Alex. You know what I mean? So any kind of statement you make, I'm not fine with. Why are you making a statement? You know what I mean? So if you asking me what I believe snitching is making a statement, you know what I mean? On anything got to do with your case other than, what you did and what only you did and not mentioning anybody else.
Well, he received a 5-year, 4-month sentence which was on the lower end, which kind of suggests that maybe that was the deal that he accepted for whatever exchange of information he gave. He ends up doing just less than 4 years. I believe 3 years.
Accepted a deal in exchange for the information he gave to these people.
What was the exchange? It was the exchange of information.
Right.
You gave information, they gave deliberation.
Right.
Here's 11 months. He went in 2008, came out in 2011. Ironically, these are the same years you were in there. I'm assuming he did not go to Victorville. He actually he went to a low also. So he went to a low, and he did from 2008 to 2011 on a 5-year, 4-month sentence. Does any of that kind of stand out?
No, because let me back up and be clear. Because you had two kind of drug statutory minimums. You got a 10 to life, and you got a 5 to 40.
The new bearskin hoodie 4.0 claims to be the most advanced, waterproof tactical hoodie ever made.
Damu
The real question is,
conversation.
this is the new bearskin hoodie 4.0.
Just say nowadays with laws as they are right now, you get caught with 5 birds or more, it's a 10 to life. You get caught with 4.5 birds, Alex, it's 5 to 40. You know what I mean? So like I said, I'm not familiar with Bleu DaVinci case, but let me be clear, you know, that they do have a 5 to 40 if he only got, say, caught with 4 birds or something like that. That's now. Back then it was different. So say you get caught with 4 birds, yeah, you don't have a criminal history record, yeah, you can get, it's 5 to 40. So say if the judge did give him 5 years, 4 months, he gave him more than the mandatory minimum. So that's perfectly fine. You know, you know, I'm not questioning the sentence because I don't know his case. I'm questioning what you said about the safety valve. You know, you have to debrief on something. You have to give them something in order to receive the safety valve. Now, I'm not clear if you saying he tried to get the safety valve, but the information that he gave wasn't enough to qualify because they already knew that. Now, if that's the case, then that's a whole different separate situation. You know what I mean? He didn't give him no information outside of probably exactly what he did or something like that. And they said, okay, that's not enough. You know, so maybe he didn't qualify. So they gave him the 5 year, 4 months, which was see, I don't know how much drugs he was convicted of. So you do have a 5 to 40 for the dude for under a certain amount of drugs. You do have a 10 to life. I happen to have a 10 to life. You couldn't go under, the judge couldn't go under 10 years. If he had a 5 to 40 in his case, due to the amount of drugs that he was convicted of, the judge could have gave him anywhere from 5 to 40 years and chose to give him 5 years, 4 months.
Diamond said, hold on, let me get back. Diamond says speculation is all this shit is. I'm staunch on being in the right when I call a man a snitch. I've seen a man lose his life and come to find out he didn't do what he was killed for. Ops don't fix that. You're 100% right as far as people lose their life for this. But we're speaking from experience, understanding the law. And I know you got ties to him, so you have an interest or certain feelings about your people, but it being your people or not being your people, I'm telling you what the law is, what's acceptable. I've been on them USPRs, and I told you the exact same thing FB did. When you said you had the transcript from Blue's debriefing, and I said from his debriefing, it will bring that. That's gonna say exactly what was said. We get Blue on the phone, he don't even got them. I say, well, Blue, do you got the transcripts? He said they didn't even record them. We watch First 48 every day. This is the federal government, not these Tennessee little small town police, Florida small town local police. This is the feds. This is what they do. Everything has to be accounted for. They got to take and collect information. That's why he's meeting with them. And he's saying that they didn't document it. Come on, man. We're going to finish this. We got about another minute of this. Then we're going to get into the work.
Months. So it don't strike a bell or it don't add up. But when you went back and specifically said something about a safety valve, you know, like I say, I also heard that Bleu DaVinci had made a Proffer statement. You know, when you do that Proffer statement, Alex, you tell shit, you know, straight up. You know, so when you talk about those two,
Right.
You know, yeah, those that's making statements, and to me that ain't cool.
If you're thinking of selling your home soon, you don't want to miss out on this. Not only will I buy your house fast, but I can also pay your next month's rent, mortgage, or cover your moving costs. Our team will buy your...
All right, that was it. So we could go ahead and stop sharing that, and we're going to bring up the work. I got the work. All right, which one we going to start with? This is the minute sheets and proceedings, the guilty plea. We might as well start there, and then we'll get to the sentencing memorandum. And then tomorrow or the next day, we might run something else tomorrow, but if not tomorrow, the next day, we'll be coming with the part 2 with the other stuff. Let me make sure that I'm sharing this so y'all can see it. All right, share screen. Boom. I got to work, y'all. There go to work. Hold on. We got too much open. All right, here we go. All right, so y'all can see that. Let me go. Slime ball live in Pacoima. Salute to Pacoima. Valley, 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 valley. Let me blow this up so that y'all can see the words.
Man, listen.
Let's blow this up. So, guilty plea and agreement, right? United States Court, Northern District of Georgia. Barima P. Knight, present at proceedings. Attorneys. All of this, right? Oh, it's finna get good. So, blow this up. But criminal number, case number, there go the case number. If you want to check the authenticity, you can pull this case. Barima McKnight, a.k.a. Bleu DaVinci, defendant having received a copy of the above numbered indictment and having been arraigned, hereby pleads guilty to count 1 thereof. The defendant, his counsel, and the United States Attorney for the Northern District of Georgia, the government, as counsel for the United States, subject to approval by the court, have agreed upon a negotiated plea in this case, the terms of which are as follows. The defendant admits that he is pleading guilty because he is in fact guilty of the crime charged in count 1 of the indictment. Then you have the waiver of rights. All of the things we talk about, the right to not plead guilty, to be tried by a jury, to confront your witnesses, all the rights guaranteed by the Constitution to any criminal defendant. We're going to skip past that. Mandatory minimums and maximums. The defendant understands that based on his plea of guilty, he will be subject to the following maximum and mandatory minimum penalties. The pleading to count 1, maximum term of imprisonment, life. Mandatory minimum term of imprisonment, 10 years. So he got a mandatory minimum of 10, and his exposure for what he was caught for was life. The term of, when I say mandatory minimum, remember at this time, and FG was just talking about it in there on his case. He said when he got up in there, he got caught with X amount of dope, which was a mandatory minimum 10 years and a maximum term of imprisonment life, right? So in this one, at that time, you can't get up under a 10-year sentence unless you cooperate with the government. You're either going to have to get a 5K1, Rule 35, or a safety valve. It's the only way for a judge to depart up under what is mandated by the U.S. sentencing guideline. Terms of supervised release, 5 years to life. Maximum fine, $4 million. Mandatory special assessment, $100. That's kind of like the common thing on the assessment. The defendant understands that before imposing sentence in this case, the court will be required to consider, among other factors, the provisions of the United States sentencing guideline. Ultimately, it is within the court's discretion to impose a sentence up to and including the statutory maximum. saying they could give him life. The defendant, and that's what they telling him when he came up for that meeting. You facing life, you know what I'm saying? And the judge can't give you life, but if you provide information for us, we'll recommend for the judge to consider, not mandate, consider, departing from the sentencing guideline. The defendant also understands that no one can predict his exact sentence at this time because ultimately it's the judge's discretion, right? The government will recommend that the defendant receive the 2-level adjustment for acceptance of responsibility pursuant to Section 3E1.1 of the sentencing guideline, and the additional 1-level adjustment if the offense level is 16 or higher. However, the government will not be required to recommend acceptance of responsibility if, after entering this plea agreement, the defendant engages in conduct inconsistent with accepting responsibility. Thus, by way of example only, should the defendant falsely deny or falsely attempt to minimize his involvement in the relevant offense conduct, give conflicting statements about his involvement. So if he would have lied to him once he agreed to this deal, then they're no longer bounded by the deal to recommend the 2-point downward departure from the sentencing guideline for accepting responsibility for what he did, right? That's standard in 100% of the deals. That's like very seldomly the judge won't depart when you take the deal because you just saved the court's money. You could get 2 or 3-point downward departure. My co-defendants, because they didn't sign the deal and they manned up and accepted responsibilities for their action, got an unheard of 4-point downward departure from their sentence. So fail to pay the special assessment or participate in additional criminal conduct, including unlawful personal use of a controlled substance, the government will not be required to recommend acceptance of responsibility. Safety valve. Based upon the information currently known to the government agrees to recommend that the defendant's offense level be decreased by 2 levels pursuant to Sections 2D1.1, Sections B9, and 5C1.2 of the sentencing guidelines. However, if the government determines that the defendant has failed to comply with Section 5C1.2A5, the government will not be required to make this recommendation. So the government deal is, if you provide us this information, we'll recommend that you get the safety valve at sentencing to the judge. Ultimately, the judge will decide whether or not he wants to give you that safety valve departure. In addition, the defendant understands that the district court will determine whether he meets each of the criteria set forth in Sections 2D1.1, B9, and 5C1.2. And if the district court determines that the defendant fails to meet any of those criteria, the government will not be required to make this recommendation. So that's the leverage that they got to keep him standing on the information that he provided. If he deviates and tries to recant any of the statements that he told them, then they won't be recommending that he get the safety valve. He will lose it. Restitutions and fines. The defendant agrees, so we ain't going to even talk about the restitution and fines. Statement of facts and recommendation. The government agrees to recommend that the defendant be sentenced at the lower third of the applicable sentencing guideline range. However, the government reserves the right to inform the court and the probation office of all facts and circumstances regarding the defendant in this case, and to respond to any questions from the court and the probation office and to any misstatements of fact or law. Except as expressly stated elsewhere in this plea agreement, the government also reserves the right to make recommendations regarding application of the sentencing guideline. Forfeiture. The defendant agrees that he shall immediately forfeit to the United States any and all interests in any and all property used and intended to be used in any manner or part to commit and facilitate the commission of the defense facilitate the commission of the offense in this indictment to which the defendant is pleading guilty. The defendant acknowledges that each asset covered by this agreement is subject to forfeiture pursuant to 21 U.S.C. 853 as property used or intended to be used in any manner or part to commit or to facilitate the commission of said violation. The defendant acknowledges and hereby waives and abandons all interest in above described assets in any administrative or judicial forfeiture proceeding, whether criminal or civil, state or federal, and the defendant further agrees that the forfeiture shall be accomplished either administratively or judicially at the government's option. The defendant agrees to waive all constitutional and statutory challenges in any manner, including direct appeal, habeas corpus, collateral attack, or any other means to any forfeiture carried out in accordance with this plea agreement on any grounds, including that the forfeiture constitutes an excessive fine or punishment. If the government elects to proceed administratively, the defendant hereby consents to the entry of a declaration of forfeiture and waives the requirements of 18 U.S.C. subsection 983 regarding notice of seizure in non-judicial forfeiture matters. The defendant acknowledges that assets listed or unlisted in this agreement may have been forfeited administratively prior to the execution of this agreement, and the defendant hereby waives any interest in such assets, all constitutional, legal, and equitable claims to such assets, and all defenses to the forfeiture of such assets in any proceeding, including proper notice, timeliness of the notice, innocent ownership defenses arising in connection with any provision of 18 U.S.C. subsection 983 and excessive fines. If the government elects to proceed judicially against any asset by entering into this plea agreement, the defendant authorizes the court to immediately enter a preliminary order of forfeiture against any property described by this agreement and waives the requirements of the Federal Rules of Criminal Procedure 7, 11, 32.2, 41, and 43 as they apply in any manner to the forfeiture issue. If the forfeiture is to be accomplished in a parallel civil action, the defendant authorizes the court to enter a civil judgment and order of forfeiture without further notice to him and waives all defenses to forfeiture as described above, including the requirements of 18 U.S.C. subsection 983 and 985, Rule 4 of the Federal Rules of Criminal Procedure, and Supplemental Rule G, Section 4, regarding notice of seizure in judicial forfeiture matters. The defendant acknowledges that he is not entitled to use forfeited assets to satisfy any tax obligations, fine, restitution, cost of imprisonment, or any other penalty the court may impose upon the defendant in addition for forfeiture. 15, the defendant warrants that he has not transferred, conveyed, or encumbered his interest. That's a crime. You could get like a year if they catch you moving, encumbering any assets to hide from any judgment. His interest in any of the assets described in paragraph 8 above. The defendant agrees to hold all law enforcement agents and the United States, its agents, and its employees harmless from any claims whatsoever arising in connection with the seizure or forfeiture of any asset covered by this agreement. The defendant knowingly and voluntarily waives his right to a jury trial on the forfeiture of the assets described in paragraph 8 above. The defendant freely, voluntarily, knowingly, and intelligently waives all constitutional, legal, and equitable defenses to forfeiture of assets described by this plea agreement. Right to modify recommendations. All right, with regard to the government's recommendation as to any specific application of the sentencing guidelines as set forth elsewhere in this plea agreement, the defendant understands and agrees that should the government obtain or receive additional evidence concerning the facts underlying any such recommendation, the government will bring that evidence to the attention of the court and the probation office. In addition, if the additional evidence is sufficient to support a finding of a different application of the guidelines, the government will not be bound to make the recommendation set forth elsewhere in this plea agreement, and the failure to do so would not constitute a violation of this plea agreement. Special assessment, that's the $100 special assessment. And he waives his appeal. DNA evidence. The parties agree that no biological evidence has been identified in this case. Therefore, the defendant understands and agrees that no evidence will be preserved for DNA testing. Freedom of Information Act waiver. So the defendant hereby waives all rights, whether asserted directly or by a representative, to request or receive from any department or agency of the U.S. any records pertaining to the investigation or prosecution of this case, including without limitation any records that may be sought under the Freedom of Information Act. And then it has cites 5 U.S.C. subsection 552. Violation of the plea agreement. If the defendant fails in any way to fulfill each one of his obligations under this plea agreement, the government may elect to be released from its commitments under this plea agreement. The government may then prosecute the defendant for any and all federal crimes that he has committed related to this case, including any charges dismissed pursuant to this plea agreement, and may recommend to the court any sentence for such crimes up to and including the maximum sentence. The defendant expressly waives any statute of limitations defense and any constitutional or statutory speedy trial defense to such a prosecution, except to the extent that such a defense exists as of the date he signs his plea agreement. In addition, the defendant agrees that in such a prosecution, all admissions and other information that he has provided at any time, including all statements he has made and all evidence he has produced during proffers, interviews, testimony, and otherwise may be used against him, regardless of any constitutional provision, statute, rule, or agreement to the contrary. Let's get back to that real quick, because this was in his deal. The defendant had to agree, Bleu DaVinci, that in such a prosecution, all admissions and other information that he has provided at any time, including all statements he has made and all evidence he has produced during proffers. So when you say that he didn't sign a proffer agreement, that's exactly what he had to sign when he went to debrief. Interviews, testimony, and otherwise may be used against him. Yael, you want to comment on that right there real quick, bro?
The fact that he had to sign that proffer to get his reward is letting you know right now, whatever information he gave them, it helped them. It had to. They're not just going to give you something for free. If that's the case, it'll be a lot of dudes walking up out of this because they said, oh, you know what? I'm going to just tell on everything that I did and I'm going to get a proffer. So I can tell them everything that I did and walk away with a proffer, right? I can walk away, right?
Yeah.
Right. Everything that I did. Not everybody else. So it's like, bro, like all of this could be it could just be settled. It could be settled if you just show us the transcripts and the recording. It'll be settled.
We got a super chat.
Oh, we got 400 Circle with the $5 super chat. He going up. $4. Let me see what that super chat say, man. Let me go back. Let me go back up. It say
right.
Here we go. I just missed it. Blue sold 0.001 albums. Shaking my head.
Yeah, they been saying
you on the road today, brother, man. Can you hear me now?
Yeah, you good.
All right. Hey, salute to you, 400 Circle Media, man. Any and everything that is given to the Damu Kiwe conversation team is highly and very appreciated. Salute to you, brother, sister, and your tribe, your family, and everybody that supports you, man. Bless you, brothers and sisters that gives to the Damu Kiwe conversation team, man. Salute.
Salute. Well, let me get back into it because I told you we're gonna read 2 of the folders and say the biggest folder for the next segment. Hold on.
God damn, it's a bigger folder? God
yeah,
damn.
my nigga. I'm trying to get the little shit out the way.
So
when I get into
not a bigger statement.
So they said that the plea agreement is non-binding. We shouldn't have to read that. And then
right.
I have read the indictment against me and have discussed it with my attorney. I understand the charges and the elements of each charge that the government would have to prove to convict me at trial. I have read the foregoing plea agreement and have carefully reviewed every part of it with my attorney. I understand the terms and conditions contained in this plea agreement, and I voluntarily agreed to them. I also have discussed with my attorney the rights I may have to appeal or challenge my sentence, and I understand that the appeal waiver contained in this plea agreement will prevent me, with narrow exceptions stated, from appealing my sentence. Hold on 1 second. From appealing my sentence, where I was at, or challenging my sentence in any post-conviction proceeding. No one has threatened or forced me to plead guilty, and no promises or inducements have been made to me other than those discussed in this plea agreement. The discussions between my attorney and the government toward reaching a negotiated plea in this case took place with my permission. I am fully satisfied with the representation provided to me by my attorney in this case. And then he signed David Maxiwak, the defense attorney, and Barima McKnight, that's Bleu DaVinci. And then you got these other, where the courts is talking about the assessment fee, $100. You know what I'm saying? And then that's the first folder. We're gonna stop sharing that. And I'll be pulling up that other one. So nothing else? You ain't got nothing else you want to say or speak up on that? Yeah.
Can you hear me, Deuce?
Yes, sir.
Yeah, man. Once you sign his name on that dotted line, you cross that line, brother. You know, and whatever you said, like I said, it could have been easily fixed. You just bringing your transcripts, man, and whatever it is you had, and you chose not to. So,
well, he said they don't exist. See, that's another cold part. Y'all ain't privy to this. I got on the phone with Blue because he wanted to clear his name, and I'm all for clearing your name, but I'm not for nobody assassinating my credibility, my name, when I'm up under some politics that's going to hold me accountable. You know what I'm saying? I watched the nigga run in the yard get stabbed up for Harvard. The nigga run in the yard, my first federal penitentiary yard for Harvard, saying that somebody was cool when they knew better and knew that he wasn't. You know what I'm saying? So up under that, I got to stand correct as a representation of my section, under representation of the politics I pledged to. So it's no ifs, ands, or buts about it. There's no reason a person should be lying about the deal he took. There's no reason a person should be talking about he debriefed and Proffer in return received the safety valve, downward departure from a mandatory minimum sentence under the U.S. sentencing guideline. But if he had them, he could have brought them. He said they wasn't recording. You know what I'm saying? Let's get to this other one real quick, man. Cause I think damn, where that's at. Damu Kiwe conversations. So we got what is this? This is the big one. We don't want to do that one. I think this is the one we wanted to do. Criminal action, sentencing memorandum. So we can get into this. You ready, y'all? So let me make sure this is the one. Yeah, I think this is the one. Defendant Pitts. And if you can't find something, I'll resend it to you. Yeah, no, I had it. I accidentally closed the folder, so I'm trying to see exactly which one it was. You got the one that's the first thing says United States of America versus Dion Beverly. Is that the same one? You got that one? Yeah, 1 second. All right. Hey, hit that like on your way in. Share. Let me start sharing this. I think this is it right here. Damn, I don't know which one it was. Damn. Okay, if I hit this one. Yeah, I think it's this one. All right. The sentencing memorandum. U.S. versus Dion Beverly. Can you see this, y'all? Comes now to the United States through counsel David E. Namajas, United States Attorney, and Robert C. McBurney and Cassandra J. Skansman assistants, and submits the following sentencing memorandum. On October 29, 2008, this court will be sentencing 10 of the defendants in this case for their involvement in the Black Mafia Family cocaine distribution conspiracy. As described in greater detail in the pre-sentence investigative reports, that's the PSI, also known as a PSR, pre-sentencing report or pre-sentence investigative report. The government's prosecution of the BMF crime ring spans several districts and involves over 100 defendants. This nationwide investigation has already yielded dozens of sentences, some of which provide potentially useful benchmarks for the upcoming proceedings before this court. Because of the scope of the BMF's drug operations and the number of defendants who will be sentenced next week, the government believes that a written discussion of two interrelated issues, role and relative culpability, could prove useful for the court as it considers what the proper disposition should be for each defendant. While the sentencing guidelines are an instructive and necessary source of information for the court, the points set forth below should add some context to the numbers and calculations contained in the PSRs. Argument. Relevant benchmarks. Two of the clearest benchmarks are the recent 30-year sentences handed down to Demetrius and Terry Flannery in the Eastern District of Michigan. The Flannery brothers were the undisputed leaders of the BMF drug empire. They directed the conspiracy in all its aspects, from the importation of cocaine from Mexico to its distribution across the United States to the disposition of the proceeds to the many members of the organization. None of the Atlanta defendants is similarly situated. Defendant Daniels, who was convicted at trial but is not being sentenced on October 29, 2008, is the only defendant in the Atlanta case who regularly consorted with one of the Flannery brothers in connection with the group's drug dealing. Also instructive is the 180-month sentence received by Chad Brown, another EDMI defendant and one of BMF's top drug lieutenants, with the exception of defendants Daniels and McKnight and possibly defendant Green. None of the defendants in the Atlanta case was as senior in the BMF hierarchy as defendant Brown. Thus, while other factors, e.g., an extensive criminal history, such as defendant Pitts possesses, may well justify a sentence for an Atlanta BMF defendant that is higher than defendant Brown's participation in the case. In the cocaine conspiracy alone should not be. Role in the offense. One of the main issues that will be argued at sentencing as to several of the defendants is the question of the role in the offense. Resolving this question is a two-step process. First, the court should determine the relevant conduct. What is the quantity of cocaine for which a particular defendant is being held accountable? Second, what was the defendant's connection to the control over that quantity of cocaine if the defendant is being held accountable only for the quantity of cocaine that he or she personally and directly sold, transported, packaged, cut, or otherwise handled? Then there should be a presumption that minor role does not apply. And they cite the U.S. versus Deveron. For several of the defendants who elected to admit in their plea colloquies to a discrete quantity of cocaine for which they were personally and directly responsible, minor role is not appropriate. For example, defendants Beverly, Fields, and Nash all sought to limit the quantity of cocaine attributable to them to those instances in which they personally and directly possessed, transported, and ultimately distributed cocaine. The government opposes minor role for defendants in this posture. For those defendants such as Hall, Hammonds, McKnight, Pitts, Shaw, and Taylor, who pled guilty to participating in the overall conspiracy, the question of minor role is more complex. Their pleas were open-ended in that the defendants did not seek to cabin their responsibility to a fixed quantity of cocaine. For them, the second step of the role inquiry is more critical. The strength of their connection to and control over the drugs assessed as relevant conduct should determine whether minor role is appropriate. For defendants such as Pitts and Shaw, who are being held responsible for kilograms of cocaine they directly possessed and sold, or Hall, who is liable only for those drugs he personally unpacked, stored, and ultimately handed to customers, no role adjustment is proper. In contrast, those defendants who may not have known the quantity of drugs they transported or whose contact with and control over the contraband was fleeting at best have a stronger basis for a claim to a minor role. So, you got leadership role, which gives you points up, increasing your sentencing, and a minor role is a way to depart, not depart under a mandatory minimum, though, but if you don't, where you don't have mandatory minimum, they could depart if you found to have held a minor role. Relative culpability. Assessing relative culpability is perhaps the most difficult part of the sentencing process in this case. Defendants are a diverse bunch, in particular because of their different connections to the BMF's cocaine business. Some defendants, Daniels and McKnight, were in the BMF's inner circle. Others, for example, so they're saying Blue was in the inner circle, but they were just arguing that it might be proper for Blue to get a departure for a minor role. That's kind of contradictory, right? Were in the BMF's inner circle. Others, for example, Beverly, Pitts, and Shaw were customers of the BMF rather than members. Still, others, Fields, Mitchell, and Nash, worked for senior BMF members and assisted them in distributing cocaine. All of the defendants, however, were part of the overall drug distribution conspiracy, either as a dealer or a worker, and have admitted as much. The critical question is, where in the hierarchy of culpability does each defendant fall? Assuming that the evil being punished is the distribution of cocaine out into our communities and the attendant harm that illegal business causes, the defendants can be assessed a relative culpability ranking derived from the quantity of cocaine for which they are responsible and the degree of their control over connection to that cocaine. The more cocaine the defendant helped move through the chain supply, and the stronger that defendant's connection to that movement, the greater his or her ultimate culpability. Given that metric, the government has arrayed the defendants across a series of culpability frontiers. So here they got a map. Let's blow this up a little bit, right? And so up here they got Beverly, Shaw, Pitts, McKnight, Dobson, Taylor, Hall, Hammonds, Fields, Mitchell, Nash, right? Using quantity as one axis, a measure of the scope of relevant conduct, and control as the other axis, a measure of a defendant's control over a strength of connection to that quantity of cocaine, one can draw a series of concentric arcs using the points of zero quantity, zero control as the center. The further arc or frontier from the 0 point, the greater the culpability. Every point on that arc is equidistant from the 0 point, meaning that the arc maps a series of points of equal culpability. This demonstrates graphically how, given those two variables, quantity and control, a defendant connected only weakly to a large quantity of cocaine has similar culpability to a defendant with strong control over a smaller amount of cocaine. The point of this exercise is not to assign an absolute term of years to each defendant based on his or her position on the graph. Rather, it is to provide a demonstrative aid for the court as it grapples with the relative culpability of the various defendants. Each defendant had a role to play in the BMF's drug distribution enterprise. Some defendants, Halls, Hammonds, Taylor, had contact with hundreds of kilograms of cocaine with an overall street value of tens of millions of dollars. Their contact, however, was limited to moving bricks of cocaine here or there and not actually selling it to a dealer or user. Others, Pitts, Shaw, Beverly, Nash, controlled much less cocaine but were directly responsible for pushing their quantity of illegal drugs deeper into the community. Conclusion: sentencing the disparate defendants in the BMF Atlanta case is a complex process that will require the court to weigh many variables. Some useful benchmarks have already been established. Damn, that's my dog. The government has identified relevant persons and has also sought to assist the court in assessing the relative culpability of the Atlanta defendants. Lastly, the sentencing guidelines as applied in the PSRs provided additional source of insight into what sentence similarly situated defendants should receive. Respectfully submitted. This is the United States Attorney, the Assistant U.S. Attorney, Cassandra J. Shinesman, Robert C. McBurman, Assistant U.S. Attorney. Certificate of service, and that was it for the sentencing memorandum. And let me see how long we got, because if it's only, if it's not a, yeah, it's already over an hour. So we're going to save the rest. Wait, I want to show y'all this one thing so y'all know how deep it's finna get. How deep is your love? Let me see. How did I find that? Okay, so that was that. Oh, I think it's on Insta. Yeah, it is on Insta. Let me go to the other Insta. That's what it was. All right, here it go. Hit that like button on your way in. I'm finna share this with y'all after I read this one. Y'all be prepared for the next one because it's definitely good. We'll get into the questions and then we're going to end it. So this is as sentencing, right? And we're going to get into this. It's a lot more pages. So the court, Mr. McKnight, come on up and stand behind the podium if you would. Mr. Macusick, as he's coming up, Your Honor, I did leave one thing out. You had asked some of the other defendants whether or not they had cooperated. Mr. McKnight was one of the individuals who did attempt to cooperate. He was debriefed. That's a proffer session by the government. But basically, he didn't know anything that was useful against the remaining defendants, right? So that happened. So he went and he talked to him. He was debriefed. And they're saying he didn't have nothing on the remaining defendants. And obviously, they're saying that's what the prosecution was looking for, information on the remaining defendants. So that happened before last week. It was months ago, that debriefing, and then we did the safety valve one earlier this week. So just so y'all is following me, so they're talking about that his debriefing was before last week, but it was months ago, and they did that safety valve one earlier this week. So he went and talked to these people and sat down and exchanged information with these people. Not one time. It sounded so tight, they had to run it back twice. He went and met with them and debriefed with them a second time. We're going to get into this, more of this, and get into them transcripts on the next one. Let's get into some of the comments. Yeah, you with me? Yeah. Look, he gone. Do Sims and Yael, salute to my brother. Salute, bro. Oh, Yael was active in the chat. In the chat, I see you active in your chat, active in the chat. My brother. Y'all get out the chat. You're on stage right now. They trolling him. CS2 was harboring Blue for years. All this chat is redundant as F. Why all y'all constant saluting cats? Let's speak on the topic. All y'all comments are making this channel seem weak. Know better, do better. Well, everything ain't what it always appears. And as far as us interacting with our people, that's what they here for. They know the content gonna come. So just get your popcorn, bro. Kick your feet up. Stop being so tax and demanding, bro. You probably ain't even hit the like button. Nigga, you getting it for free. Come up over here telling us how to do our business. But salute to you, man. You must be new to the page. Yeah, Queen for a Day agreement. Signed the Queen for a day. You want to get at home money? I hide them. All right. 2 Capone. Bonnie Hunter, nigga. What's up, homie? What's up? Black One, salute to everyone in the chat. Salute. They was active. Look, we had another super chat and didn't even do it. 400 Circle Media. Y'all be easy. Salute 400 Circle, man. We finna be out. Let us just get through some of these comments. I know people, condolences to Big Messi and family. Hey, man, condolences to Big Messi and his family, man. We definitely got him in our prayers. Let's talk about that today. Too many signs showing he dropped the dime. Yeah, y'all. It was too many signs. Sing, dudes. No, I can't sing. Hey, but I got something to go out. That boy, right? Yeah, laugh out loud. So he's snitching. They didn't use his information. Well, it's already confirmed. That was what y'all was talking about at the beginning about confirming information they already got. Sometimes all it takes is 2 people to corroborate one fact, and they know that they'll be able to utilize that in court. And that's one of the reasons they ask you about all of the crimes that you did when you debrief, preparing you for potentially have to take the stand. But my boy sent me something, man, and it's nasty work, man. We gonna go ahead and play this. Where that thing at? Oh man, this was hilarious. Hold on. Am I still sharing the thing? I hope I ain't sharing that right now, because if I am, I need to unshare it. And yeah, I got to unshare that. Stop screen sharing. And I'm finna play this for y'all. Hit that like on y'all way out. But before y'all go, man, I need y'all to check this out, right? Share screen. It's hilarious. Bleu DaVinci, we got a dedication for you, man. It's nasty work. Let's go here.
Easy, niggas do it. Tell on they homie crime and sign on that dotted line. There's a lot of niggas snitching, I don't know who to trust. Every time a nigga hit them, people say it's us. See, I beat and did way too much time. If I'm gonna tell him, kill a nigga mom, he should go get a job and stop trying to be in them streets. Pulled up, pop, now the nigga resting in peace. He like, oh, I'm ready to die. Yeah, once when you testify, you can't change your mind, not even get no paper, cause you signed them fucking statements. Oh, tell me again that you won't tell on your friend.
Hey man, stop snitching. The movement is easy. One more time, going out. Hey, salute. Hit that like button on your way out. We go.
There's a lot of niggas snitching. I don't know who to trust.